Hey guys, welcome back to my channel. So today in this video I would like to read an article entitled "The Far from Halcyon Isle Maritime Liens, Renvoi and Conflicts of Law." 1. It is a great honor to be invited to give this address to the annual conference of MLAANC. I was in my final year of Sydney Law School in 1977 when the first retreat address was delivered by the RT Bonzer Ninian Stephen. The address now serves a significant educative functions for our two nations' maritime professionals. 2. Ships are probably the paradigmatic examples of the effect of cross-border insolvencies. The commercial failure of a ship on an international voyage had been a well-known legal problem for perhaps millennia before the more recent advent of the collapse of a multinational cooperation or corporate group. 3. Ships can incur not only debt but liabilities anywhere they sail. The principles of what we know broadly as maritime law development over time to deal with recognitions of what claims each forum will recognize as enforceable against a ship when she enters its port. For in this address, I want to explore how a maritime lien can be classified and which choice of law rules may be used to ascertain whether a foreign maritime lien could be recognized under Australian law, particularly in light of the High Court recent development of Australian private international law rules. I will discuss the Privy Council's controversial majority decisions and dissent in the Halcyon Isle concerning to the choice of law for recognitions of a foreign maritime lien and the competing theories of whether the private international law doctrine of renvoi may apply in relation to Australian law. Maritime liens and contract. Lest it be true that his collections of topics sound like it came from the over-excitement mind of a professor of law, I must reveal that it is a greatly simplified part of the subject matter of a case that I heard recently which was settled. I do not propose to give any of the answer that I came to build, rather I will work through some of the issues that arose in argument. The problem in the Halcyon Isle. First, I should give a little history from the News Straits Times of 9 September 1974 concerning the arrest of this 17,000-ton oil tanker, Halcyon Isle. She was part of a fleet operated by the London-based company Court Line. Court Line collapsed in mid-August 1974 during the recessions caused by the oil price crisis. The ship, which was registered in London, had been mortgaged the previous year to a British bank. Because Court Line was in financial trouble, the ship could not take on a full load of provisions when she called at Dubai on 11 August 1974 and rode for Singapore. She broke down in the Straits of Malacca just after her owner's own collapse and was without her engines or generators for a week until she was towed into Singapore on 5 September 1974. Earlier, on 28 August 1974, the bank began proceeding in Singapore and obtained a warrant for the ship's arrest in support of its claim over the $14 million. On the same day, Todd Shipyard Corporation, the New York Reapers, the necessary men who had worked on the ship in their Brooklyn yard in March 1974, also issued a writ in Singapore claiming about 240,000 for work, materials, and interest. When Halcyon Isle was arrested, her crew told of their week-long ordeal while stranded without power and with food and water running low. The New Straits Times reported that in desperation they tore up deck boards to cook their food. When the ship was sold, the proceeds were insufficient to satisfy all the creditors. The necessaries men claimed priority for the maritime lien they had until Title 46 of the United States Code. That brings me to the legal history. In December 1972, in the Loanis Discalalis, the Supreme Court of Canada had upheld a similar claim by Todd Shipyard for a United States maritime lien as having priority over a ship mortgage, even though no such maritime lien was conferred by the Canadian law. In December 1977, the Singapore Court of Appeal decided the Halcyon Isle by following the Supreme Court of Canada. It upheld the necessaries men's assertions that the laws of Singapore would recognize their maritime lien as created of the law of the place of its creation. Being there, the lex loci contractus and gave the lien priority over the bank mortgage. The bank appealed, and the questions for the Privy Council was whether a maritime lien that arose under the lex loci created a substantive right that the law of the forum lex fori should enforce, or whether only those categories of maritime lien that arose under the law of the forum should be enforceable. All of their lordship agreed that the law of Singapore on this issue was the same as the law of England. The majority Lords Diplock, L. Wyn Jones, and Lane held the English conflict of law rules provided that the laws of the forum or lex fori govern the questions of recognition and priority in respect of maritime liens. They held that, accordingly, the only maritime liens that could be enforced were those that could be maintained by inaction rem pro in England. In example, maritime lien enforceable in the English Court of Admiralty for salvage, collision damage, seamen's wages, bottomry, and the statutory maritime liens created in the 19th century for master wages and master disbursement. In the majority, only Lord Diplock was a recognized commercial judge with some maritime experience. In contrast, Lord Salmon was a commercial judge with maritime experience, and Lord Scarman had commercial experience in appellate work. They held that a maritime lien was a right of property given by way of security for a maritime claim, and if validly conferred by the lex loci, was equally entitled to recognitions in the forum by an action in rem as foreign mortgage that was validly created by the lex loci. Effectively, the difference between the majority and minority was that the former classified the right to proceeds in rem on a maritime lien covered by a foreign law as procedural, and the latter classified it as substantive. So the time is up, and the article will be continued to read on the next video. So bye bye, and don't forget to like, comment, and subscribe. Bye.